we're going to start talking about long-term Medicaid and long-term care. So, Medicaid was part of the 1965 passage of Medicare, Lyndon Johnson, and the Great Society. Sir, in the back, could you kick that door closed a little bit? Medicaid is a federal program. It came about again in 1965 with the passage of Medicare. The problem is it's a federal program with federal statutes and federal regulations that they dumped on the states and said, hey, states, you administer and manage this. So do you think the rules are exactly the same in every state? They are not. What you should know about Connecticut is your clients are fortunate to live in Connecticut because we have one of the most expensive Medicaid programs in the country. At least if it's measured by what it costs to go to a nursing home here. Alaska is the only state, as far as I know, that is more expensive than Connecticut. There are parts of New York that are equally or more expensive. So the program, people frequently get it confused with Medicare. We find lots of folks who think that Medicare is going to pay for long-term care. We'll get there. We'll talk about that a little bit eventually. To be eligible for Medicaid, then you're a citizen or a Connecticut resident, okay? 65 plus or blind. Now their waivers, see, one of the things about Medicaid, it is an incredibly complex set of rules. Because we have this overarching federal law with the federal regulations. The Center for Medicare and Medicaid is where most of this comes from. Okay? But then they have provisions for waivers and exceptions. And in fact, they have exceptions to the exceptions of some of these things. So, blind or disabled, you need to be medically eligible. That means you've got to have health care problems such that you need health care, significant health care. And assets less than $1,600. That's not income. That's assets. Okay? Now, we're talking in the context of a single individual. Are there single individuals in married couples? No, it doesn't depend on the relationship. Okay? This rule applies to the ill spouse. We have rules for the well spouse. Okay? Do you think your clients or the people in general know that you can only have $1,600 in assets? I find routinely they're shocked. And you mean income. And even that, okay? So, after qualification, the program pays for the nursing facility care. Or we have a waiver, an exception to the Medicaid rules called the Connecticut Home Care Program for the Elderly. And we have community first choice. And we have money follows the person. Those are all exceptions to the Medicaid rules. They're waiver programs. Okay? The recipient's income is going to be paid to the nursing facility, except for $60 a month. It wasn't that long ago, it was $90. That's not a good trend. Yeah? I mean, what does it cost to get your hair done? Not everybody. I don't know. Okay? You can spend money to pay your health insurance premium. Okay? We can allocate some income to the spouse. We'll talk about that a little bit. There are rarely any other deductions that apply, but there might be depending on individual circumstances. So essentially, everything is going to go, that individual has is going to go to their care. So here's a kind of a graphic of it. We have the applicant and the spouse. You can have exempt assets or non-countable. We'll talk about some of these as we go along, okay? And we have non-exempt. All non-exempt means it has to have been consumed. Does it have to go to care? No. It does not have to go to care. Many a nursing home would like to make sure that it goes to care, but no, it does not have to. It has to be consumed. That means that the individual has to get a benefit from it. Okay.
You mean the spend down? Is that what you're talking about? What has
Well,
to be consumed? I didn't know.
I'm saying consume because spend down frequently gets confused with you got to spend it on care. Okay? So yeah, this is spend down, but you don't necessarily always have spend down. So we're going to go through some examples as we do this today. Okay? So the residence is commonly, exempt, but you notice I said maybe. Why might it be a maybe? If I'm married, I got your attention. You awake now? If I'm married, I go to the nursing home. We own a house together. Is that house exempt?
Yes.
As long as my spouse is living in the house, it's exempt. Yes.
Is the reverse mortgages in place here?
Oh, excuse me, I made an agreement. So please write that down and we'll address it, okay? So much more fun when I just take questions, but you didn't want me to, okay? Okay, so we own the house jointly. I'm in the nursing home. My wife dies first. Is the house exempt if I have qualified for Medicaid? How many, let's do this. How many of you think the house is still exempt? 2 or 3, good. Maybe? No. Because I am a joint owner. When she dies, it becomes mine. I'm in the nursing home. I've got to sell it, and we've got to reimburse the state. That's bad news. And trust me, that happens. Okay? Property for a trade or business if it is essential for self-support. Well, I'm in the nursing home. What trade or business is going to... So this really is only applying to the community spouse, the well spouse, right? Okay? Non-business property, again, essential to self-support. These rules are there. They're very hard to ever find circumstances where they apply. Okay? But I'll show you where how this one works in one of our examples later. Household goods and personal effects. If I have a Renoir on the wall and a Chagall on the other wall, do you think those are exempt?
No.
I wouldn't try and get by that. Okay. So within reason. Okay. And a motor vehicle. What kind of motor vehicle?
Something that is not new.
Actually, you can go buy a brand new car.
Just one.
Okay? But just one. Not two. Not one for me and one for you. It's just one. Again, married couple. Okay? We have a life insurance policy so long as the face value is no more than $1,500. Now that, when I say face value, that's the amount that the insurance company said they would pay when it was purchased. How many of those do you think are still around? They haven't been selling those for 30 years. Okay? Term insurance. Where this can be a big deal, where you have retirees, where their company has furnished them continuing group insurance. That insurance has no cash value, and so it can continue on. We don't have a problem paying for it because it's being furnished, right? So that is where this exemption works pretty well for the family. We just have to make sure we get the beneficiary right, okay? For personally owned term insurance, the problem is if you gotta pay for it.
Right.
And one of the big problems we usually have is having enough money to do what we need to do just to live, let alone pay for insurance. So where this really works well is employer furnished group term insurance. You know, state employees have it, you know, with teachers, I mean, whatever. Okay? An irrevocable burial reserve plus soft goods. It was either last summer or the summer before the legislature increased the amount that could be put into an irrevocable burial trust from $5,400 to $8,000. And so that, when we said the irrevocable burial reserve, that's what we're talking about. In addition, you can prepay for what the funeral directors call soft goods. I haven't ever figured out what the limit on that is. Trust me, the funeral directors understand this real well. So I mostly have left it to them. I've never had anybody that was going to have a funeral and the whole thing. But what they haven't been able, by parsing their prepayment between the irrevocable burial trust and the soft goods contract, that they haven't been able to have the funeral they wanted for the family. Okay? Now, how much can you give away to any one person in a year?
13.
I hear 10, did I hear any other numbers?
13.
13, I got 13, can I get 14? I got 14, can I get 15? I got 15 and we have a sale.
Oh, really?
Okay. Here's the deal with that, okay? That's a rule, and lots of people are familiar with that rule. In the context of Medicaid, it doesn't exist. And quite frankly, for 98, 99% of the population, it's a rule that has no meaning today. We're not going to get into estate taxes and gift taxes and what have you, but for all practical purposes, a middle-class person can give away as much as they want to whomever they want in any year without even having to worry about that rule. The only thing you got to do is if you get above, and it is about 15,000 this year. It was 14 last year. Okay? That's the annual. It's called the annual gift tax exclusion. And all that you're excluding from is you're excluding from having to file a gift tax return, so long as your individual gifts to people is no more than that per person. Filing gift tax return is not a big deal. Okay? So, but when it comes to Medicaid, Medicaid doesn't want to know these rules. They don't apply. So we say, I say, exempt transfers and for value and gifts, but I want to focus on the gifts first, even though it's in reverse order, hopefully it's not confusing. Is people like almost all of you have heard about this amount that you can give, and it's an exemption and it sounds good. No, it's not when it comes to this. Because that's a gift tax rule. Medicaid doesn't care about gift tax rules. Okay? So we have exempt transfers and we have transfers for value. Let's look at what some of these exempt transfers are. The spouse. You can transfer as much to your spouse as you want. There's no limit on it. It does not create a penalty period, because what we're worried about here, are we going to create a penalty for Medicaid purposes? Okay? If you transfer it to a third party for the sole benefit of the spouse, who might be another party we could transfer stuff to?
Disabled child.
Well, that's a different rule. We could actually transfer it to a trust so long as it's for the sole benefit of the spouse. But if it's for the sole benefit of the spouse, it still counts, okay, as an asset. So we got different rules we have to pay attention to as we go on here. No, to a disabled child, that's a separate exemption, is so you can transfer assets to that disabled child, and that doesn't count, okay? But now it's theirs, and if they're disabled, then you probably have disqualified them from other benefits they might be eligible for. Not necessarily, but you gotta understand that, okay? A house to a caregiver's child or sibling of the applicant with an equity interest in the resident, okay? So that caregiver child exemption is a great one, because we see lots of children who are involved in helping take care of a parent. The requirement is that that caregiver child, the care furnished by the child had to be sufficient to keep the ill party from being in the nursing home 2 years. Now, do you think that the children go out and talk to the doctor and say, you know, Doc, I need you to write up now that Mom would be in the nursing home except for what I'm doing? Do you think they do that? No, but your clients will do that now when they start helping Mom out. Right? What's it going to be like after lunch? Okay? So the caregiver child exemption only works if the child can prove that it was their care that kept their parent out of the nursing home for 2 years. And I'm in the middle of one right now where we're trying to get the doctor, because the child didn't think to go do this, and he's taking care of Mom for actually a number of years, way over the 2 years. We're trying to get the doctor to give us something in writing that we can hang our hat on with confidence. I'm going to have to write it because we're on our second try and the doctor still hasn't got there yet. Okay? So you have to go through it. Sibling with an equity interest. The law is unclear about how big that equity interest has to be. We know in other states, I've talked to other practitioners, I've never done this, maybe as little as a 5% ownership interest is sufficient to keep the property exempt, and you transfer it to the spouse. Now hopefully you have a sibling, you've got a really young sibling that you can transfer it to so you can figure out how to get it back to the kids. But okay? All of these things, what you'll see as we talk about these rules, it gets complicated because one thing impacts the other. And if you use this rule, then what does it do over here? Transfers for value, if legitimate and not exorbitant. Okay? Well, here's a transfer. I go to Foxwoods with my entire net worth and I put it on the roulette wheel. Is that a transfer for value and not exorbitant? How many think it's a transfer for value? None of you. One of you. Okay? He's right. That's a ridiculous part of the rules. That is for, now, you better be able to show that that's where the money went and that you really did lose it. Okay? Because now you've got, because we have people who sometimes routinely don't want to deal with checks and won't use credit cards, and so they go to the bank every month and or every week, and they draw out $500-600 or something like that. Well, that's not a good practice because you can't tell what happened with the money. And what makes it even more interesting when it goes to $1,000 or $2,000 a week, you better be able to explain that. Okay? So of course, nursing care, living expenses, legal fees, okay? And purchases of exempt assets. So when people are told that they need to spend down, what they should know is that especially for married couples, it's much less so for single individuals, that there are a lot of things that money can be spent on. You know, that kitchen remodel that you've been wanting to do, now you got a reason, okay? The car that you have been hanging on to because you really don't want to buy a new one, but you'd love to have a brand new Tesla Model S, you can actually do that, okay? But you would have to take possession of it, I think, okay? So you figure out the things that in individual circumstances make sense. And sometimes there's a lot of things that, especially with older clients, they've got a ton of deferred maintenance on the house, okay? Dad stopped doing it. Mom thought it should be done. It never got done. Well, now you go out and hire somebody to do it. Maybe mom has some developing issues, and we really need to redo the bathroom. Right? You figure out what makes sense, and as long as you're getting value, you can pretty well spend your money however you want. So, yes. Is selling the house to the kids for $1, is that a sale? How many thinks it's a sale? It is a gift. Because first off, did you get the $1? Okay? So it's a gift. If you got the $1 and the house is worth $100,001, well, it's a gift of $100,000. So this doing the quick claim deeds, which a lot of folks do, for many reasons, a bad idea. I'm not going to get into why it's a really bad idea, but if anytime you get less than fair market value, let's come back to the house you sold for $100,001. Fair market value is $200,000. Okay? If you sold it for if you got $100,000 from the child, and it was really worth $200,000, you still made a $100,000 gift. Yeah. So anytime we do this, we're going to end up with a period of ineligibility if we need to get help paying for medical care, for Medicaid. So it's a calculation, okay? You take the amount gifted, divide it by the divisor, that's the months of ineligibility. That divisor, it will get a new number in, we'll get a new number in July. Actually, we'll probably have a new number in a couple, 3 weeks, okay? So let's say if we give away $12,604, what's the resulting math tell us? 1. We have a math major back there somewhere, okay? So that says that if on I'll make it 6/1, okay, of 18, we made that size transfer 60 months later. If any time from there to there we apply for Medicaid and we're otherwise eligible, okay? Now, how much can a single person have and be otherwise eligible? $1,600, okay? So we're down to $1,600. And somewhere out here, let's say, we're in the nursing home, we made this transfer, are we going to get Medicaid to pay for the nursing home? How many think we're going to get Medicaid paid for the nursing home? 1. Thank you for voting. Okay? No, it's not going to pay. It's not going to pay between in 5/1 of 18. After that, they will. Okay? What if it is what if it's 126,000? Yeah, we got a 10-month penalty. See, this is the dreaded 5-year look back, because really, if this is where we applied, they're actually going to come back to 4/1 of 18. I said 18 down here, I meant 23. Okay? Didn't want it to be too terrible. Okay? So we come back to 4/1 of 18. That's our 5-year look back. Now, if we actually get down the road here and we don't need the nursing home until 4/1 of 23, and we did make this big a transfer, we'd actually come out pretty good. We only have to pay for figure out how to pay for 1 month, and then Medicaid's going to take care of it, right? Or actually, 2 months. We have to pay for 2 months. We have to figure out how we're going to do that. Okay? But if we don't do the transfer, see, because some people think that there's a rule or a law against making transfers or gifts, and if you do that, you can't qualify. That's not true. What it says is if you do it, then you have to have a plan as to how you're going to pay for the care you need if it shows up in the 5 years. That's all the rule says. If you never make the transfer, and this gets lost, and I want to make sure I get this across, okay? If you never make the transfer of that $126,000, when will it ever be safe from your long-term care costs? Speak up.
Never.
Never. If you never use the rules, you never benefit from them. And it continues to be exposed until you die. Now, and we said, now Medicaid comes into play mostly for folks over 65. There are plans for folks younger and a lot of different circumstances. What are the odds of needing long-term care if you make it to 65? Anybody know?
Like 30%?
30%? Would you believe 70? According to the Center for Medicare and Medicaid, which I think they have pretty good statistics, since they're the ones behind paying the bills, okay? If you make it to 65, there's a 70% likelihood you're going to need long-term care before you die. The only question is, at what point, and at what levels, and for how long? Now, the state insists that that's the average cost in a nursing home per month, $12,604. I'm going to tell you, in my experience, I don't have a single client who has private paid for a nursing home in the last 2 or 3 years that has paid that little. Mostly what we talk to folks about, you got to expect $14,000 or $15,000 a month. Okay? I used to talk about $18,000. That was my Fairfield County number, Stanford down in there, and their facilities right around here close to it's $18,000 a month here now. Okay? It's a huge problem. So do you understand the look-back period a little bit better? I bet I get some questions on this one. I can take questions.
Can you
What?
take a question?
No.
Oh.
You've got to write it down. You've got to write it down.
I wrote it
Because
down.
they were mean. They wouldn't let me take questions. It's more entertaining when I can take questions. Okay? So what's really critical is the date of application. Because you can see here, if in this scenario that I put on the board over there, with only a 1 month gift, not a big deal. Okay? No matter when it happens, if we got a plan. If we made a bigger gift, it's more critical that we have a plan as to how we're going to pay for it, if it happens during that 60-month period. But quite frankly, with the right plan, as long as you know how you can recover what you've transferred, it's not a big deal. It's a heads I win, tails I break even. Okay? How many things in life is heads I win, tails I break even? I don't get many of those. Okay? People used to be worried about transferring assets into trust because we've had a 60-month look back for transferring trust for years. With the Deficit Reduction Act of 2005, which was effective in February of '06, we had the same 60 months whether it goes to an individual or to a trust. We got the same look back issues. So, another diagram again, single person, exempt, $1,600. Non-exempt, that money we have to have done something with it. The non-exempt either has to go into exempt resources, and for a single individual, there's not much. We have succeeded in for somebody who has transportation difficulties, we have managed to buy a modified van as an exempt resource. So they're very limited in terms of what we can do here, okay? Transfers for value, your imagination is, the limits. It just needs to not be totally unreasonable, okay? You always wanted to go to Ireland. Go to Ireland. Okay? And the fact that it costs you $25,000 for the plane ticket, but never mind. Okay? There might be some issues health-wise with being able to do some of these things. Okay? So, Community Spouse Resource Allowance, the CSRA. This is the amount that the community spouse is allowed to retain from the assets of both spouses. Because you have clients out there that think, I got mine, and my spouse has got his or hers, and I'm okay, and we're spent. No, that's not how it works. You have to combine them all. The most the community spouse can keep is no more than 1/2 of the non-exempt resources, except if that is more than $123,600, you can't keep the amount above that. So think of it this way. A couple with $300,000 in non-exempt resources, how much can the community spouse keep? $123,600. Somebody with $200,000, how much can the community spouse keep? $100,000. Somebody with $100,000, how much can the community spouse keep? $50,000. The rule is, I think, incredibly unfair. We actually, one of the things that the NALA chapter here in Connecticut lobbied on, what year did Malloy, when did Malloy get elected?
2008.
2008. So in 2006, we got the legislature to pass a change that said, okay, you can keep you can keep whatever you've got up to whatever the limit was then, okay? And it lasted for a year. Malloy got elected, they made a bunch of changes, and it went back to this silly rule, okay? The income allowed for the community spouse, 150% of the poverty level for a family of 2 plus excess shelter. Y'all know what that is, right? Well, sure you do, because I put it on the board. This is what that translates to into 2018. A minimum of $2,030, a maximum of $3,090. Okay? Yeah. The thing that this doesn't tell you is a community spouse, a well spouse, can keep all of his or her income no matter how much it is. So you got a retiree with a pension and it's paying $7,000 a month, and that's a community spouse, how much can they keep? $7,000. What does that tell us about what we have to do with the ill spouse's income? What do we have to do with all of it? It's all got to go to care. If, however, you have that same spouse with $7,000 of income, it has a community spouse that has zero income, how much of the $7,000 can we send to the community spouse? At least $2,000 up to $3,000. So we can take that ill spouse's income and transfer it to the well spouse. See, this stuff's easy, right? Yeah. The minimum monthly needs allowance, it can exceed that community spouse income if they have exceptional circumstances. Do you think the DSS ever finds exceptional circumstances? Not easily. Not easily. But if you have facts that will support that, then you can increase that income level to allow the payment of what's necessary under those exceptional circumstances. The only place where we've been really successful with this is when we had the community spouse who had serious debilitation, and we could keep them home with home care coming in. And we did have to go to a fair hearing, and we did win the fair hearing, and were able to increase that community spouse's income well above that $3,000 limit. So it's a very much individual facts and circumstances test in terms of what you can do there. Medicaid, have you heard of Medicaid compliant annuities? Anybody heard of those? Okay, Medicaid compliant annuities were provided for in the Deficit Reduction Act of 2005. And it said if you buy an annuity that does the following: it's irrevocable and non-assignable. That means you're going to give the insurance company a chunk of money, and they're going to give you a stream of income, but nobody else can acquire that stream of income. You can't give it up. You can't sell it. Can't gift it. It just is. It is the deal that it is. Okay. It's got to have equal payments over no longer than the life expectancy of the annuitant. And the annuitant here, that's the person who's receiving the payments. That's typically going to be the community spouse. Or well, it has to be, in fact. Okay? The Department of Social Service, actually the state of Connecticut, has to be named as the beneficiary for anything that's left at the time the community spouse dies. Okay. Now, if your annuity meets these requirements, then we can put money into it for the benefit of the community spouse and increase his or her income, because basically what the law said, what Connecticut was doing before the NAILA chapter here helped fund the lawsuit against Connecticut. It's called the Lopes case, where we had to compel through the courts the Department of Social Service to accept Medicaid annuities. But that's a way in which we can make sure that the community spouse has as much income as they need, assuming we've got enough resources to buy a big enough annuity. This is a great way to preserve assets, and we'll come back later and show you how we actually use that, okay, for the community spouse. Have I spoken Greek so far? Okay.
Can we break that rule about questions for this one?
Write it down.
Can we revote?
Write it down. Okay? Write it down, please. I'm trying to become a rule observer, not rule breaker. So, look here, married couple. We have exempt resources up 1,600 for the institutionalized spouse, okay? We have non-exempt resources that some of which can go into the annuity for the benefit of community spouse. We have the community spouse resource allowance, okay? We have dollars that are available for spend down. We may be able to do some transfers for value or convert to exempt assets. Whatever we don't end up doing over here is going to end up going to nursing care. Okay? So it's about figuring out the best way to use what's there, okay, to try and maximize the overall value for the community spouse. So here's an example. We got Mary and Bob. Yeah, they're in assisted living. And they're only paying $5,500 per month. Okay? Mary's income is $1,600. Bob's is $2,100. Bob has Alzheimer's. It's getting worse. They moved him to the nursing unit. And now we got different monthly expenses. Mary's is three grand a month. Bob's is $13,000. So they got total expenses of $16,620. They have non-exempt resources of $190,000. Survivor's income, because this is one of the things you got to think about when you're planning for married couples. What's the economics going to look like for the well spouse when the ill spouse passes? Now, it doesn't always work out that the ill spouse passes first, okay? But that's generally a fairly reasonable assumption to make, okay? Unless you're me. And then we had a client who he came in and he decided he really should do some planning. He was in his 80s. His wife was 10 years younger, but she's in the nursing home. And she has a brain tumor. The survival rate is less than 5% over an 18-month period. And she's failing, and that's why she's in the nursing home. And so we do planning. We're assuming that she won't survive the 18-month period. At the 19th month, we said, we need to revisit this. And we did. So we went back and we redid all the planning, saying, we don't know who's going to pass first. Okay? We know she needs help. Okay? She lived 10 more years. Her husband died 4 years before she did. So you gotta create as much flexibility in this planning as you can. And it's really important that we also take into account what kind of income stream the survivor's going to have. How are we going to make that work? Right? So this is an example of. This is what happened. She's only got $2,300 if Bob dies. So no planning, no appeal. We got a community spouse resource allowance of $95,000. Remember, she had 190. So she only gets to keep 95, right? And she's denied due to excess resources. Why was she denied? Because she still had 190. Okay? After excess is spent, Mary and Bob reapply. So her income $1,600. The interest on the community spouse resource allowance is $118.75. Okay? And we get to push over to her $1,122.25. That's a calculation we actually did. This is numbers from the real case. Okay? And she's able to keep $2,800. Okay? But what's her problem? she needs 3,200. Okay, and when she dies, she's got 2,300 plus 18, she got 2,400, and it's going to be shrinking because she's having to dig into her $9,500 to make up the shortfall, so the interest goes down. Is this a good position to be in if you're married? No. So, two, let's take and use rules. We go buy a Medicaid compliant annuity, and we're assuming you get $820 a month out of $68,000. Okay? Now, we're not going to get $68,000 for out of $68,000. We're not going to get $820 a month forever. So you don't. The annuity doesn't have to run for the full lifetime, life expectancy of the community spouse. It can be shorter. So they use some of those, and they spend the $48,000 or not. Maybe she needs a new car. Maybe she needs some new clothes. I mean, maybe the house needs work on it. There are a lot of things that we can do with that $48,000. The first thing is make sure she's got enough income. Okay? And so now she still has the same $9,500. Okay? We're assuming how also that we could maybe get her to qualify for the maximum of $3,022. That number is actually 90 now. Okay? It may not be possible to do that, so we'd fall back to the lower number. And you look at it, 1,600, 118.75, 820 annuity income. We get less income from Bob because we have the annuity income. That means Bob's paying more for his care, right? But now we've got Mary at 3120. Survivor income, if Bob dies, she actually has 3228.75. Is Mary happier? She should be able to stay where she was, okay? Because her costs were about $3,200 a month, and we know assisted living facilities never raise their rates, right? Okay? So when you're doing this, you got to think about those kind of things. How do we cover that? Okay? So, estate recovery. Federal law mandates that states are to make an attempt to recover from the estate of the care recipient, the benefits. And with the probate assets, any life insurance is payable to the estate. Life insurance is an asset that is pretty easy to make sure it's never going to be subject to these claims. But anything that's in the probate assets, and we can't have legally liable relatives. I don't know if I talked about it. I don't remember if I talked about it in here, but Connecticut a few years ago passed a statute that says that if you make transfers, and because of the transfers you can't pay the nursing home for care, and you get care, and you can get care and not have paid for it, that if you made a transfer to, when I say you, your spouse, an agent under a power of attorney, a trustee under a trust, if you have made a transfer to somebody within 2 years of the time you receive that care, before that, the nursing home can sue not only you, they can sue your spouse, they can sue your agent under the power of attorney, and recover their full private pay rate plus attorney's fees if they're successful in a suit. So you've got to pay attention to this stuff, because sometimes you'll end up with people implicated who didn't know that they were signing up for any personal liability. Okay? The whole legally liable relative thing is mostly not a big deal here in Connecticut, but Pennsylvania has a statute that dates back to colonial times that says that a child can be responsible for the necessaries of their parents. And there have been a number of cases now where in Pennsylvania, the child has ended up having to pay for the folks' nursing home care. public benefits. Okay? We got Medicare. Medicare, unlike Medicaid, you get because you're old enough. How old do you have to be to get Medicare? 65. Or you have to have been on Social Security disability for 2 years. Okay? Now, why you have to qualify, and then you don't get any help with paying for care for 2 years. I never understood that. Okay? It's for 65 and disabled persons. Here's kind of how it breaks out. We have Part A. Part A is essentially hospital coverage. Part B is the doctors and all that sort of stuff. How long? I can't remember when they added Part D. It's not that long ago. It was during Bush's administration. They added Part D, and we have prescription drug coverage. And I find it really interesting. You create a program where you're becoming one of the largest buyers of drugs in the country, and you say, and we won't negotiate prices with you. In fact, it's a crime. But that's Part D. That's tremendously helpful to people. The problem with Part D is this is all through private insurers, and they all have drug formularies. They say they have to have, basically, this is not accurate, but as close an explanation as I can do simply, is they have to have a drug available for every single medical condition that a drug can be prescribed for, which is easy to read, right? But they only have to have one. So you have to be careful when you're signing on for a Part D program. You make sure that the drugs that you're going to need over the course of the next year are part of the formulary. That's predictable, right? No, okay. But it is better than nothing. And I have clients today who are alive because they have Part D. Okay. You ever see these drugs advertised on TV? These new biologics and whatever. I don't know if they're all this way, but I have a client, one of it's, is it Otezla? Can't remember the name now, it's a cancer drug. $15,000 a month. And fortunately, he has retiree health insurance and is paying for it. I don't know if the typical Part D program would cover it. I don't think so. And so you can then, and there are things that, with Part B, you've got co-pays and deductibles and heart and that. And Part A, you have deductibles that you have to pay. Which after the first 3 or 4 days turns into hundreds of dollars a day for care. So a lot of folks have supplemental coverage. Med subs, they're referred to. They're A through N or some such thing. The coverages of these Medicare supplements, what they have to cover for each one of the different classes is mandated by law. They can't have different coverages, but they can charge any premium that they get the state insurance department to approve. There can be hundreds of dollars, in some cases even $1,000 in cases that I've seen, difference in the premium for the same class of policy depending upon the company. So it's important that people shop carefully for these things. Okay? Or you say, I don't want to do any of that. I want a Part C plan. Okay? Which typically is Part A, B, and D all rolled up into one thing, and it comes from, all of it comes through a private insurer. Okay? They are paid on a per head basis. How many people do you have in the system, and this is how much we're going to give you. And there's some folks who really like it, because frequently it will save them money. But most people, as they get older, are going to come to a point where they want traditional Medicare. Because the incentive to the insurer is to, if they're going to be profitable, they have to find some way to minimize the amount they pay out. Because they only get X number of dollars. Okay? Part B, we already talked about. So Medicare, a lot of folks think it pays for long-term care. Does it?
No. 2 weeks after hospitalization.
2 weeks after us. No, Medicare will pay some for long-term care. They will pay for rehabilitation, okay, in a nursing home. It's to fix you to get you out. They will, if you get y'all seen the 4-day vacation? You familiar with 4-day vacations?
No.
Yeah, 4-day, you don't get any vacations, right? No. 4-day vacation means that you got the day you leave, a couple of days, and the day you come back, right? But they're 3 midnights. So you have to think, you get Medicare to pay for rehabilitation in a nursing home, you have to have had an admission. You have to be admitted, not observed, over 3 midnights. If you don't do that, they don't pay anything. And I don't have this up here, but the hospitals are incented, they have an incentive to not admit you. Now, it's going to be, it's explained in their world. It's explained in their world differently. Is they have an incentive to make sure they've taken good care of you so that you don't come back for at least 30 days. Okay? So what they tend to do is they tend to want to observe you. I've had people with untreatable broken hips that they didn't want to admit. Well, I could tell you some stories that would make your hair turn gray. Oh, you've already heard them. So you've got to be sure you get that admitted stay. And I can tell you with proper advocacy, you can frequently get people admitted that are only going to be observed. Because we have one client who called us to say, she didn't do it. So we got a call, broke a hip in the hospital, got an observer, she's 82 years old. And so we get involved that night. Christine, I think you've met her, my social worker, her predecessor. We got involved, we advocated, hey, she's 83 years old, she's got a broken hip, you're telling me she's not a surgery candidate, she's non-weight bearing, we got to figure out how we're going to manage this pain. It's best done here. We got her admitted. We got another client, similar problem. The family didn't call us, don't know why, and they sent her home the next day. Kept her overnight. There's a case out there that's settled, and I don't know how you say demo. I've heard it pronounced several different ways. Versus Sibelius. It's a settlement of the suit because once you get into the facility, Medicare, does Medicare want to pay you a long time? Okay, short time. Okay? And it's for rehabilitation, remember. Okay? They'll pay 100% of the first 20 days and all but $169 a day after that, up to 100 days. Up to. Okay? The way this was handled for a long time was the facilities will say, well, you have to be making progress or Medicare won't pay us. Some of you heard this, right?
I've heard.
You got to be making progress, right? No, that was never the law. The law is you have to be benefiting from the services. Now, if you... Damn. I got to develop better radar here. I'm I want to creep up on you guys, I gotta stay back, okay. If the services are allowing you to maintain functionality, that's benefiting. So physical therapy is a great example. If you're not getting the physical therapy, and especially the older you are, the more likely you're immediately beginning to deteriorate if you're not getting the physical therapy. Therefore, you gotta make the argument about benefiting, because once they say we're not gonna pay, you get a 48-hour notice. If you don't appeal it, it's over. It's frequently over even when you do appeal it, because when you appeal it, they say no, but you gotta keep working through the system, okay? So this was a big deal. This has allowed a lot of people to get care they needed, to stay in the facility longer so they could get out. That's what they just don't get, okay? So Medicare, we want to talk about pretty limited. Private pay from assets or income. Now the state says it's $12,604. I think it's more. Well, let's call it 13. So we got a 70% probability of needing long-term care if you're over 65. The average stay in a nursing home, if you get that far down the line, is 2.8 years. I'm going to call it 3. $13,000 a month for 12 months, $156,000, right? 3 years of that is almost $500,000. That's on average. Okay? This is the largest financial problem the middle class has in front of it, and most of them aren't even thinking seriously about it. Okay? Even when they've had friends, neighbors, parents who've gone through it and lost everything. It's a big deal. Long-term care insurance. Long-term care insurance, we can talk a little bit about it. I'm running out of time to be on time here. Something like only about 6% of all the costs of long-term care are paid by long-term care insurance. It's a very small player. It's something I think everybody should think about as part of an overall plan, but I do not believe it is the panacea for a number of reasons. First off, you may not be able to get it. It's hard to qualify for it. If you get it, most the folks who are still selling traditional long-term care insurance, 100% of the marketplaces reserve the right to change the premiums. And they do, and they have, and they will continue to. There are other alternatives that I'll call asset-based products. They're either life insurance that you can turn the death benefit into long-term care, or annuities that you can leverage the value in the annuity to pay for long-term care. That oftentimes, by taking a broad look at a situation, you can figure out how to maybe help cover this risk, because it is very real, okay? Now, the veterans benefits. Always talked about veterans benefits just a little bit. I've got a few more slides down here. The one that helps the most is called the age attendance benefit. The VA refers to it as pension. Why would you, if you didn't retire from the service, expect to get a pension from the VA? I don't know. But it can be about $26,000 a year for a married couple. I've got some other slides. I didn't get the numbers updated on this yet. About $14,000 a year for a widow of a qualified veteran. And we'll cover those in a minute. Okay? So, long-term care, they've got a rule. You're going to typically have problems with 2 or more of the activities of daily living. Dressing, bathing, transferring, continence, walking, or have a cognitive deficit such that you need companionship, supervision to keep you safe. But 2 or more of those, or the cognitive issues. Underwriting's a big problem. If you've got something that's likely to kill you, you can probably get long-term care insurance if you've got health issues. But if you have arthritis, you've got bad knees, you've got a bad back, you have diabetes, you've got arthritis, the long list of the chronic conditions that we see in our elderly. And at what age does elderly start? I don't know, when you start having chronic conditions, I think. I don't know. It's a big problem. I've talked about the 3 different ways. The partnership program is Connecticut, and now most all of the other states have this program. If you have a qualifying long-term care policy, that is a limited number of those that are sold because they require that you have to have an inflation factor to your benefit. Because y'all think 13,000 is a big deal, right? Would that hurt anybody's budget? Yeah, that destroys the budget, right? 13,000 a month. At 6% a year increase, which is the midpoint of the increase in Hartford County over the last decade, 5 to 7% of the increase in nursing home costs. In 12 years, that 13 will be 26. If the increase continues at 6%. I think I did that math right, I guess. Some math here. Okay? It's a big deal. Partnership program, to the extent it pays out benefits, you have a dollar for dollar protection of assets. But you have to think carefully about this because it's only protected for the insured who receive the benefits. So if you have the typical plan that says, honey, I love you, you get it all when I'm gone. If honey then has a long-term care problem, that protection you paid for is not protected for him or her. So it is, as I said, I come from having 40 years of estate planning experience. Okay? It is much easier for me to take somebody who could write a check for this place and protect most everything they have than it is to help a middle-class family keep what little bit they've managed to create out of a lifetime of hard work. The rules are that complicated. But the partnership program can be very helpful. I think I've covered enough on those. The age dependence benefit, the widowed spouse and dependent or disabled child, all of the eligibility relates back to the veteran. The only one that has to meet the eligibility requirements in terms of service, etc., is the veteran. The medical requirements, the spouse has to meet, the disabled child has to meet. Okay. Now, lunch is next, and there's a folder, there's a little brochure in your materials that will tell you more about this. Looks like this. If you know World War II veterans, Korean veterans, veterans of Vietnam, and it's Vietnam era veterans, you never had to go to Vietnam, you can be a Vietnam veteran like me. Okay? Northern California and Illinois, instead of Texas. Okay? This is a very, very valuable benefit. You have to qualify militarily. You have to qualify based on income and assets. They got totally different rules, totally different than Medicaid rules. We help people qualify for this all the time. And on your gold sheet, if you would like to attend a workshop that focuses just on the veterans benefit, put VA workshop, and if we do one, we'll try and make a point of inviting you. Okay? So I promise to take some questions. Yes, now your question.
Title 19.
Title 19.
Title 19 is changed with Medicaid.
Title 19 is the U.S. Title 19, and that's Medicaid. They're all the same. So if anybody has some questions left over from what we talked about in the morning, I'll try and take a few of them, considering an extension of lunch. Yes.
Now, can you say something about timing for applying for Medicaid relative to long-term care? Like, when should you do that?
At exactly the right moment. Thank you for such an easy question. You want a better answer. Well, when you talk about long-term, are you talking about long-term care insurance?
No, for long-term care services. In other words, for nursing home care.
Okay. Well, you want to apply as soon as you see that you are going to be eligible. Okay?
Okay.
Now, and that's too simple of an answer, because sometimes you want to apply, depending on whether you've done planning or not, sometimes you want to apply and trigger a penalty period and get it to run so long as you figured out how you're going to pay your way through it. Okay? So I give you a simplistic answer to a very complicated question because it really depends upon the individual facts and circumstances of the person who's receiving the care. Married couples, you frequently are going to apply even before they're eligible because you've got some time after the application date to get them eligible. So, you know, I went to law school, and there's something you don't know about when you go to law school. You get a special license that lets you talk out of both sides of your mouth. And so the only really correct answer to the question is it depends. Okay? But you need to ideally plan for it instead of react to it. Okay? I saw several other hands. Yes.
Out in the field, I've heard from people that have experience going to an estate planning lawyer, a range of costs for that service. One person told me $5,000, another person told me $10,000, and I just wondered, you know what the average cost is to come and do?
The average cost will fall between $2,000 and $25,000.
Based on your profile.
Yeah, see, here's the problem. What does a car cost? On average. Okay? Because the problem is, I'm trying to convey a lot of information to you folks today. Are you beginning to see there's a lot to this?
Yeah.
And what the part we haven't talked about, and we're not really going to be able to talk about it other than we do have these 3 case studies, is it depends on the facts and circumstances of the client. It depends upon the expertise of the attorney, the law firm representing them, and the scope of services that they're delivering to the family. What I will tell you if you have any clients who are really price sensitive and they think they can solve this with documents and that's how they're trying to price it, don't go see any attorney. Don't go see any attorney. Don't come see us. Go on the internet and get what you can off the internet, because there is no practicing attorney who has any real competency who can run a practice and stay in business and compete with a computer. So there's way too much focus on price and absolutely no consideration of cost. And if I have time today, I'll give you an example of price versus cost. Because the cost is what you've got to be concerned about. The price is far less of an issue, and you are asking about price, not cost. Yes?
A lot of people have tax-deferred investments, and when the state goes to calculate the value of that, to figure out what you got paid for this nursing care and stuff, do they look at the tax value or what it's actually worth to you?
The payment of the taxes are your problem, not the state's. They don't care. Okay? So they look at what's the account statement say. The fact that it's an IRA or a 403B or 401K or a profit sharing plan, they don't care. What's the account statement say? Okay, I saw another one. Yes, Christine?
Talking about Medicaid eligibility, being a Connecticut resident, is there a time frame? Like, people have to have been living here for 2 months or 2 years, or?
Basically, for Medicaid, if you've moved here, you've taken up residence here, can't see through all the heads, okay? If you've taken up residence, you're expressing the intent to remain here permanently, in most cases, you're gonna be eligible. They're and yes,
When should you see an estate lawyer?
at 18.
Okay, past that.
Okay. Then you've arrived, okay? Now, I'm being a little facetious with the answer to 18, but I really do believe, I wish I could draw lines of it. I really do believe that all 18-year-olds should do at least essential planning. Because, and the good news is, most of them will not need it for a long, long time. The vast majority won't. But we talked about living wills earlier. The fact that you have the right today, it's considered constitutional law, you have a right to decide how your life should end. Okay? You don't have a right to commit suicide, but you have a right to decide what that looks like. We have that right because catastrophic health events that happen to young women. All the cases are young women in their 20s, early 20s. So I am very serious that if you don't have everything in order, I'm very happy that you haven't needed it. You should get it in order as soon as you possibly can. Yeah. But please understand, my outlook is colored by the fact that I'm the oldest of 4 boys. I've got one brother left. So we all died a lot younger than me. And one of them had serious chronic health issues for the last decade of his life. I mean, this is very real stuff. And the good news is most of us get by for a long time without doing anything. But then you have such messes when it's not taken care of.
So
Yes.
for a very simple, uncomplicated will, legal Zoom would be adequate? Is that what you're saying?
If all you want are documents, yes. Okay?
For the 18-year-old.
But if you actually want a plan as opposed to a document, that's different. Okay? Our practice, we certainly use documents as tools in our practice, and I'm getting off on stuff I really didn't intend to talk about today. But the focus on our practice is helping you figure out what's appropriate for you, building the tools that you need to get the results that you tell us you want, and then having a system in place to make sure they work over time. Okay? We're talking about all this stuff, but quite frankly, you know, we use a euphemism, an estate plan is matured. You know? How many of you want your estate plan to mature tomorrow? You never get any takers. Okay? So you want to consider what the outcomes you want, meet with somebody who will spend the time to help understand what those are, help you understand the consequences of what you think you want. Because a lot of times there are things I think I want, but when I look at the ramifications, I say, no, I really didn't want that. We help people do that. We help people put plans together. I'm also pretty good about saying, you know, because of what you want and what your priorities are, we're not the right firm for it. Okay? I figured out a long time ago, there's only just so many people that we can help in any given year. So we have some processes to try and figure out, are we right for you, are we right for us? But we were going to talk about, there was somebody else I know had a question. Who was it? That was it? I exhausted the questions? All right.
I gave you my question during the break, but
Oh.
you said you were going to address it later.
Okay, well, we'll get into trust, et cetera, in a minute. Okay? The VA benefit, we've got the service requirement. It's only 90 days of active service. It has to be for other than training, so if all the veteran service was for National Guard purposes, training doesn't count. But only one day had to be during those war periods that I talked about, World War II, Korea, Vietnam. with a couple of exceptions, you never had to be in Vietnam. And likewise, you never had to be in Korea, you never had to be in the Pacific or European theater. You merely had to be in the military service. Okay? You need problems with 2 or more activities of daily living. Those are bathing, showering, dressing, eating, toileting, incontinence, walking, transferring, supervision to be safe. Limited household assets. The VA has rules about how much assets you can have, but they also have rules about what, well, yeah, they do have rules, but in terms of what you can do to arrange your assets so you can meet the asset thresholds. Okay? Countable income. They've got the VA, if you call the VA and ask, say, if you find somebody who understands this benefit, they will ask you questions about both your income and your assets. And for the most part, you will be told you don't qualify if you're living reasonably comfortably. But they're not telling you about all the rules that allow you to modify both your countable assets and your countable income. Because that's not what they're trained to do. I was one of the first attorneys accredited by the VA here in Connecticut to help veterans do this stuff. And I go sometimes a month or two without talking to somebody who the VA hasn't told you can't qualify. But we hear all the time, we hear from people that with just a modicum of planning, they can qualify. This is, I haven't updated this from 2016. These numbers change every January. They're higher now. The single veteran is about $22,000 a year. Married veteran is just over $26,000 a year. The widowed spouse is just over $14,000 a year. And a vet married to a vet is right about $36,000, so 35 something. Okay? So it's a pretty meaningful benefit. Hollis was telling me in one of the facilities in West Hartford, they've got a memory unit, and is a unit that is dedicated to working with people whose real problem is just cognitive issues. They're talking $4,000 a month. I don't know if that's a special, get you in the door deal or whatever, but for a single veteran, you've almost got half of that paid just from this benefit. This can make a huge difference. And what I know is there's never been more than about 5% of the potential eligibles who get this benefit. So that's why we always talk about it when we get a chance. The way we manage the income side of the planning for a veteran is we try and make sure that they have all of the appropriate and reasonable for their circumstances unreimbursed medical expenses. One of the classics is, I bet every single one of you either has a friend or a client or a relative where one of the children has been devoting a fair amount of his or her time taking care of a parent, right? Mm-hmm. And do they get paid for it? Mm-hmm. No. Is it free? It's not free. Uncompensated caregivers represent about $400 billion in lost productivity and in expense. And the VA says it's okay to pay your child for what they're doing, but you have to do it right, because when you do this planning, you've got to think, okay, what if we get to where Medicaid's an issue? Whatever we do for the VA, we got to know how we're going to deal with it if we get to a Medicaid situation. Okay? But often, assisted living, home health aides, daycare program. Sometimes one of the best things we do is get a senior from their house to an adult day center, so they have other people to react with, to interact with. Okay? Everybody wants to stay home, but staying home by yourself is solitary confinement, not so good. Okay? There's co-pays or prescriptions. There's a lot of things that we can usually help organize and ferret out to help Transfer of assets. Medicaid, what's the look-back period for Medicaid? 5 years. Okay. What's the look-back period for the VA? No days. There's been a proposal that's now 3.5 years old by the VA to create a 3-year look-back. Doesn't exist. So we can rearrange your over assets, we can rearrange your assets so that they're protected and don't count for VA purposes. Okay? But, and at this point, since it's been 3.5 years and there's been an incredible amount of pushback and there's been no modification made, I don't know if this thing is a threat that we thought it was going to be, because I'm not going to get into complications. It made it incredibly complicated. It made the 5-year look back on Medicaid seem simple. Okay? We can get help. Every single one of the veterans organizations, the VFW, the VAV, the Disabled Veterans of America, all of them have some folks who've been trained by the VA. Okay? And they're really good at helping you get materials supplied to the VA. The problem is they don't get any training in helping you plan, and oftentimes they will help you submit an application, and then you'll get denied, and it can take a year or longer to get a case restarted once it's been denied, if the denial was proper. Okay? I had a woman in my office here 3 or 4 years ago, very successful and run her own business. She had her MBA, etc., and she was a type A on steroids. And she thought mom was entitled to this widow's benefit. And she had somehow, and I honestly don't know how she did this, she kept mom's claim live with the VA for 3 years. I figured out in 5 minutes of talking to her and in about 10 minutes looking at her information form why mom was never going to qualify. That's why I'm so impressed that she kept this claim alive for 3 years with the VA. Okay? And she had committed what, in terms of time, had to be tens of thousands of dollars worth of her time. So the rules are complex, but for the vast majority of people, the planning to help them qualify is not that difficult. We've got accredited agents. Last I knew, there were only a couple hundred of those in the country. I know 2 or 3 of them. And again, they're really good about helping veterans submit an application when they're already qualified. They're really good at helping people who have service-connected problems get an application in. The thing about the VA, it's both a good thing and a bad thing. The VA views itself as a non-adversarial organization. They're there to help the vets. And they really are. But it's the biggest bureaucracy in the world. And so you can keep a claim that in a different system would have been truncated and done with. You know, you can keep it alive for 3 years and it should have been over and done with in 6 months, because they keep giving you chances to come back. Okay? As long as you don't miss any of the firm deadlines, and most of those are pretty generous. And then we've got VA accredited attorneys. You know, they didn't start accrediting attorneys until 2008. I was, I think, 10 or 15th here in Connecticut accredited. There are a lot that are accredited, but not many of us actually really do anything with it. We're amongst the group that the VA accredits that are best capable of helping people plan and figure out the direction they should go.